Can I please pick up one or two points from before the short adjournment? One was my Lord Justice Nugee's point about the diary. What the revenue were provided with was a list of days and a location on each date. And in support of that location, one receipt was referenced. So the day may say Zermatt coffee receipt, and then it went through for the same for the UK for Ireland. For each day there was one receipt. Of course, I didn't provide any breakdown of activities. And as the court will be aware, for the receipts in the UK, the appellant was not able to provide any explanation of what she was doing. And the receipts in the UK, we had a number of them because the revenue requested those receipts from the taxpayer. The second point, my Lord, was there's just this Falk's point about Pendragon and Edwards and Bairstow. I can try to pick up on that and try not to spend too much more time on it. I believe that the case that my lady may have in mind was the case of Markham and the Financial Conduct Authority.
There's that, but actually it's Lord Justice Henderson in De Gorse at 75. Markham may pick that up.
It doesn't specifically identify De Gorse, but it confirms that where the question of where there is a question of fact, the test is in Edwards and Bairstow one to find an error of law. The point that in my submission still stands from Pendragon is that the question of, and this is Lord Hoffman, or citing Lord Hoffman in Moyna and as well as Lord Lawson and Serco, is that the question of whether something is a question of fact or law is in some degrees a policy question, and in particular those cases where you have an evaluation of the facts, so where there is not a pure dispute of fact, but rather an evaluation of the facts to determine a statutory question. And you'll have seen in Pendragon the reference to Lawson and Serco in paragraph 34, and Lord Hoffman says in that this was about the scope of the Employment Rights Act. Like many such decisions, it does not involve any finding of primary facts, none of which appear to have been in dispute, but an evaluation of those facts to decide a question posed by the interpretation which I have suggested should be given to section 94, namely that it applies to peripatetic employees who are based in Great Britain. Whether one characterises this as a question of facts depends, as I pointed out in Moyna, upon whether as a matter of policy one thinks that it is a decision which an appellate body with jurisdiction limited to areas of law should be able to review. And so the building blocks in Pendragon upon that position of Lord Hoffman in Lawson and Serco and in Moyna was to identify the particular special role of the Upper Tribunal as one that has a specific fact-finding capability and also a role in providing guidance to tribunals generally.
Okay, can I just point out that what Lord Justice Henderson says in De Gorse is that what Carnworth said shouldn't be taken as effectively undermining the correctness in that case of the Upper Tribunal applying what Lord Justice Lewison said in Fage and Chivani, and his comments there related both to primary facts and to evaluations.
Yes. Apologies, the researchers over lunch had only got me to this one, and apologies for not picking up the course as well. Then, my Lord, can I go back to moral obligations and clarify how they feed into this question of exceptional circumstances? This really does raise what my learned friend referred to as the pleading point. If I can invite the court, please go to page 160 in the hearing bundle.
My page numbering disappears. Can I?
Is this in the skeletons?
Oh, apologies. Sorry, apologies, I've given you the wrong reference there.
Is this your skeleton you want?
No, sorry, I was meant to be finding it in the FTT. It is page 100. Sorry, not 160, 100. So we'll come back to these paragraphs when dealing with inconsistency, but it's in the second half of paragraph 181
the FTT had said moral obligations and obligations of conscience, including those arising by virtue of close family relationship, can qualify as exceptional circumstances, and those obligations may be strong enough to prevent a taxpayer leaving the UK. And then the following paragraph, in our view, the combination of the need, and just identify the word need because the Upper Tribunal pick it up, the need for the appellant to care for her twin sister and particularly for her minor children at a time of crisis caused by the twin sister's alcoholism and does constitute exceptional circumstances. So it was the need, so it was effectively the moral obligation that the taxpayer was saying she had, which was said to constitute the exceptional circumstances. Then, if I could invite you please to go to how the Upper Tribunal was dealing with it at page 51 of the Bible. You'll see at paragraph 1, just above paragraph 100, there is the side heading internal contradiction. And paragraph 100 through to 106, the Upper Tribunal deals with that point about internal contradiction and perversity. And I'll come back to that to deal with that ground. Then there is a subheading whether there were exceptional circumstances. And you see that then there is findings of fact, a subheading just above paragraph 109. And this was my learned friend's submission that this was a finding of fact, and the Upper Tribunal explained there why they disagree. And that is the point that I've been have addressed already. If I can pause there and jump please to the grounds of appeal, which are at page 15 of the bundle. You then, if you see paragraph ground 3 on page 16, the footnote references to paragraph 110 of the Upper Tribunal's decision. So what the appellant was challenging was that question of law versus fact at 110. There is then no ground of appeal challenging the paragraphs that follow that. And it's in the paragraphs that follow that the Upper Tribunal considers how moral obligations, whether they can feed into exceptional circumstances. So that point hasn't been a focus in certainly the revenue skeleton argument because it wasn't the following paragraphs are not ones that were challenged specifically. But one can see, my learned friend made oral submissions on the point, so if the court considers this.
I haven't understood this. Ground 4 Nugee erred in holding that moral obligations cannot be part of the exceptional circumstances. Isn't that the point?
But the reference is to the challenge to the earlier paragraphs, which is, I suppose, why the parties have been looking at those earlier paragraphs, which are actually dealing with the question of prevention rather than moral obligation, because that was how the Upper Tribunal picked it up earlier. But we can, I can address you on these paragraphs that follow, which include the moral obligation and exceptional circumstances. But I just wanted to.
But sorry, I'm not sure I've read this either. Ground 4 expressly says, erred in holding that moral obligations cannot be part of the exceptional circumstances. Are you saying that because of the way the footnote works, it's really about prevent?
My lady, that was the understanding that we had when drafting the skeleton argument, that what was being challenged was those paragraphs of the Upper Tribunal decision, which are referenced there.
But isn't ground 4 very plain on its terms?
Well, as I say, my lady, if you permit me to park that point, I don't take any objection to the points being raised, but I just wanted to identify why those particular paragraphs weren't focused on in the revenue skeleton argument. But my learned friend has addressed you on paragraphs 111 and onwards, and maybe I can show why the Upper Tribunal was correct in its assessment under each of those subheadings. The first is the second statutory example. As you've seen, the Second statutory example refers to life-threatening or sudden illnesses. Doesn't use the word serious, life-threatening or sudden. And the Upper Tribunal there make the point that the sister's illness was neither life-threatening because the suggestion of suicide had been rejected, nor was it sudden because it had a long history. So the Upper Tribunal, in my submission, were obviously correct to find that neither of those two markers were satisfied. Then at 114, dealt with the submission by my learned friend that the taxpayer's case was more serious than, inverted commas, the usual case. Well, that really comes back to the contradiction point, which I'll come on to in a moment. And then 116 is the moral obligation point. And at 107, and they're dealing with it because the FTT had found that the taxpayer needed to care for the sister because of the moral obligation. 117, we've already found that the moral obligations are not in themselves exceptional circumstances. They are instead part of normal social and familial interaction. Objectively commonplace circumstances do not become exceptional by adding a moral obligation. The FTT was wrong to find the taxpayer's sense of moral obligation and or need to care for the sister change the position. And in my submission, the Upper Tribunal was entirely right to find that if the circumstances themselves are not exceptional, and this is a point I'll come back to when dealing with the internal inconsistency, then to say that the taxpayer considered that she needed to be here for that reason doesn't then add to it, doesn't give it a greater sense of exceptional circumstance. So if I
I'm
could...
having great difficulties with this. I think it's all tied up with the prevention point. You haven't really addressed us on the prevention point. You're going to do that?
Yes, ma'am.
That comes later. But just so you understand my difficulties at the moment. As I understand your argument, you have a set of circumstances which are objective and transparent and verifiable.
Yes.
Somebody is ill. You have to ask the question whether that's exceptional. Well, that is a question of how unusual or uncommon or out of the ordinary that is.
Yes.
And we know that the FTT found that the alcoholism of the sister by itself was not exceptional, but what Mr. Kessler described as the crisis was. And that's your ground, it's his ground 5, I think, as to whether that's a permissible finding and the inconsistency. But let's assume that it was exceptional. You then have to ask the question, did that prevent the taxpayer from leaving?
Yes.
Now, surely when you ask that question, it depends on things like, was the taxpayer the only person available to deal with the crisis? Was the taxpayer sufficiently close to the person who's ill to make it morally compelling for her to stay? If it had been a complete stranger who was ill and she'd just turned up at some friend's house and the children were unkempt, I wouldn't have thought that would prevent her from leaving. Might be a nice thing to do to stay, but she wouldn't feel compelled to stay. But if it's her sister and she turns up and somebody needs to do something about it and she's the only one who can, why is that not something that can feed into preventing her from going out?
Well, my lord, it depends upon the interpretation of the word prevent in that context. If it means it stops you going home, and as the Upper Tribunal found, through means of a legal or physical inhibition, that the test, the quintessential facts that would fall within the test are that somebody is in the UK and something sudden, unexpected happens to them. They break their leg and they cannot fly. They are prevented from flying. They cannot physically leave the country to go home.
You can actually fly with a broken leg.
But it depends. I use that example.
But I mean that's quite a good example, because if you break your own leg, it may be nonsensical to fly. So you're not actually physically prevented from going, but it would be against medical advice to do it. Is it the revenue submission that prevent means legally impossible or physically impossible? Is it that narrow?
My lord, there was discussion about the example of the doctor's advice before the Upper Tribunal. Clearly, there may be circumstances in which the doctor says you're advised not to fly, but physically you could get on the plane. The revenue is not going to say that you act contrary to doctor's advice. That it is only in circumstances where you literally physically cannot get on the plane that the exemption applies. No, that is not how the revenue consider that legislation applies or intend to apply the legislation. But if you imagine something that is less serious, but imagine that it can still be an exceptional circumstance, and you choose not to fly, but there's no advice saying you just would find it more comfortable not to fly, then that might be a situation in which the revenue would say you're not prevented by the exceptional circumstance from flying. And that's all. And those, of course, are examples where the person starts off in the UK and something happens, and the question is, can they leave? In the particular circumstances of this case, you're dealing with somebody who wasn't in the UK, who chose to come to the UK, and is saying, I am prevented from leaving the UK, which is a quite different fact pattern. The question is still a statutory one. At the end of each day, was she prevented from leaving? But in circumstances where somebody has made a choice to come to the UK, similar to that posited by the FTT that I referred to earlier, they suggest that Parliament's intention would be that if somebody has a sick relative there and the person thinks that they should, I think I ought to be in the UK, then it is possible to show that you were not prevented from leaving. It's possible to show that you were prevented from leaving. And the revenue does say that that is wrong, where you have a choice to come to the UK. You have not been prevented by the exceptional circumstances from leaving the UK.
That's a slightly different point. I understand that point. If you choose to come, then you can't say I was compelled to stay, because you weren't compelled to come in the first place.
Right.
That's a slightly different point from saying if you happen to be here and had intended to go home, but the situation was such that you felt compelled to stay, you say that's not enough if the compulsion is not a legal compulsion, or a physical compulsion, or a doctor's advice, but is merely your own sense of what your obligations to your family require you to do.
Correct. That is what we say the position is. And my own friend's submission on this point is to raise the question of the analogy with the reasonable excuse test or the duress test. The effectively, well, I did what was reasonable in the circumstances, therefore I was prevented from leaving. But in my submission, my lord, that analogy is inapt, because in those cases of reasonable excuse, what you have is the taxpayer having not done something that they should have done, file a tax return, for example, like many other situations. And the question is, why did they not do it? Did they have a reasonable excuse for not doing it? There is no part of the statutory test in paragraph 22 that concerns the reasonableness of the taxpayer's response to a situation. It is, as we say, an objective test to be determined by the FTT on the evidence available to it as to whether the taxpayer was in fact prevented from leaving. And if they made a choice to stay, albeit one that they felt they should take, then they were not prevented from leaving.
I mean, if it has something to do with whether you have a choice, then people almost always have a choice when there is some emergency confronting family members. So, for example, in circumstances like the present case, the taxpayer could have said, well, it's not my problem. I'm going to leave the children. I'll ring up the local authority and tell them they ought to be taken into care. and I'm off. And maybe a hard-hearted person would do that, but a more decent person wouldn't. So where do you draw the line? Do you say that any element of choice means that you're not prevented, or is the test something to do with the way in which a person with decent views in accordance with common societal values would act?
My lord, I do want to make clear that it is no part of the revenue's role, if you like, to pass moral judgments, and we do say that it is no part of the statutory test to consider what is reasonable or decent or common, what would commonly be done in those circumstances. It may be that everyone might understand why a particular taxpayer acted in the way that he or she did, but the result of that, unless you fit within the four walls of the statute, is that it is just an extra day that counts towards your residence. And it may be that because you have acted in a way that other people would have done, that you end up at the end of the day being resident in the UK, with the consequences that you are taxed as if you are resident in the UK. But
So any element of choice means that you are not prevented. Is that right?
if you could, subject to the points right at the margins, like the one that my Lord Justice Nugee floated, I could choose to act against medical advice. At the margins, my Lord, no, you obviously have some element of free will in those matters. But we do say strongly that the question of what would society expect, or what is sort of morally right or wrong, or what would the ordinary person do, is not an element of this test. Parliament has...
So any element, any illness or accident of a family member is something where you do have a choice whether to go, but that is not enough for being prevented. Is that right? Is that your position?
There was the discussion earlier of an adult with a minor child, and whether there may be a legal obligation, neglect of family members may feature in that.
Put aside legal obligations.
But yes, my lord,
Yeah.
Where the choice is one that has been made to either come to the UK or to not leave the UK because of an illness of a family member, but you can actually leave, or you choose not to, we do say that the prevent element of the test is not met.
Okay, well that's very clear. Thank you.
And that is the interpretation that the Upper Tribunal put on it. It did so because of its understanding of the word prevent, both within other authorities such as the FCA case, but specifically applied to this particular statutory context. And there's no challenge on appeal to what the Upper Tribunal said as to the meaning of the word prevent in this statutory context. I was taken into prevent by my Lord Justice Nugee's question about the subject. I believe that I had finished moral obligation within the context of exceptional circumstance. So unless there's anything further on that point, I will leave that. But I do say, just to wrap that back up, that when one takes paragraphs 109 through to 117, the Upper Tribunal's reasons for finding there were no exceptional circumstances are correct and should stand. That then takes me back to the question of internal inconsistency, and this is the ground 5. This was an Edwards and Bairstow challenge. We can see and so therefore not affected by any question of law versus fact. It's pure Edwards and Bairstow.
And we can see the inconsistency in the hearing bundle at 41, please. The relevant passages are set out. And you can see, my learned friend has taken you to the passages, but the first one is at paragraph 179 of the FTT's decision, down at the bottom of page 41 of the hearing bundle. And it's in particular the last line: alcoholism and depression are not in themselves uncommon or unusual illnesses. It is true that both conditions cause much suffering and distress. And then these are the important words that my learned friend missed out the second time he read it. Both for the individual concerned and for the individual's family. So, alcoholism and depression, which cause much suffering and distress for the alcoholic and for their family, are not exceptional circumstances. And we do say that that is inconsistent with paragraph 182 of the FTT decision, which is quoted there, paragraph 45 by the Upper Tribunal. In our view, the combination of the need for the taxpayer to care for her twin sister and particularly for her minor children at a time of crisis caused by the twin sister's alcoholism does constitute exceptional circumstances for the purposes of the paragraph. But if those medical conditions can cause much suffering for the individual and their family, then the need to care for the individual and her family, we say, cannot logically be an exceptional circumstance. And we can see how the Upper Tribunal dealt with this in page 51 of the hearing bundle. We've been shown, it starts at paragraph 100. We've been shown, my submission is 102. That is one if I effectively repeat to this court. And then 103 and 104. 104 was my learned friend's response to argue that there was no inconsistency because of the position of the taxpayer and her family went beyond mere alcoholism, and there was a degree of squalor that was greater. But the Upper Tribunal accepted, and I submit to this court, that the FTT made no finding about the degree of suffering and distress caused by the sister's alcoholism and depression. No finding to the extent that that was more than would commonly arise in families who are affected by those conditions. There is simply my learned friend would have it that these circumstances are more severe, but there was simply no finding by the FTT to that effect. As to the point about expert evidence and judicial notice, my learned friend says now, well, the FTT didn't need expert evidence because it could have taken judicial notice of the seriousness of impacts on a family in the inverted commas ordinary case and the impact on the family in this case. But there is this, against that, the starting point is there is no such finding that was informed by judicial notice or otherwise, and it would, we say, have been improper to have taken judicial notice of that fact. And we have an authority cited in our skeleton argument to support that submission. We have it in the authorities bundle, and it's the Privy Council case of Scotland Attorney General, and there is at page 211 of the authorities bundle a statement of what judicial notice is. And this is in the opinion of Lord Kerr. This was a case about the level of general damages that are awarded in the Bahamas, and on this point in particular, whether one could take judicial notice of the difference in living costs between the UK and Bahamas if one was starting with the UK's JSB guidelines. And paragraph 40 Lord Kerr says, judicial notice is the acceptance by the courts of facts or a state of affairs which are so notorious or so clearly established that evidence of their existence is deemed unnecessary. And then there's a reference from Cross and Tapper. Judicial notice refers to facts which a judge can be called upon to receive and to act upon either from his general knowledge of them or from inquiries to be made by himself for his own information from sources to which it is proper him to refer. 41. Moreover, the party seeking judicial notice of the fact has the burden of convincing the judge that the matter is so notorious as not to be the subject of dispute among reasonable men, or the matter is capable of immediate, accurate demonstration by resort of readily accessible sources. And we do say that the question of whether the facts in this case were more serious than would ordinarily be the case for somebody suffering alcoholism or depression is not a matter on which the FTT could have taken judicial notice. In any event, that's not what it did.
It's a bit hard to think, isn't it, what an expert would actually have said.
And the FTT, my lord, made reference to the expert evidence. What is that there was one point that the Upper Tribunal raised. The more fundamental point is there was no finding of fact by the FTT to distinguish the position it readily accepted in 179 was not an exceptional circumstance from the position as found in the particular case.
I have difficulty with this submission because the FTT here's the evidence as to the facts which were taken to by Mr. Kessler. Dysfunctional, crisis, all those words he pointed to. The FTT comes to the conclusion that can be properly characterised as exceptional circumstances. They must have appreciated when they came to that conclusion, 185 I think it is, they wrote at the back of their decision, that they'd previously said, we accept that alcoholism in itself is not that uncommon. So they themselves must have been drawing a distinction between the mere fact that your sister's an alcoholic and the facts that they have heard evidence about in this particular case. What's wrong with that? I mean, that's not sort of saying we're taking judicial notice of the fact that alcoholism normally doesn't cause squalor like this, and this is out of the ordinary. They're just saying, well, alcoholism itself we accept is not unusual. But we think this situation, which we have described and we've heard evidence about, and we accept that evidence, falls into the category of something exceptional. I have great difficulty in seeing how that can be characterised as an inconsistency. What they're doing is saying this is not just alcoholism, it's got these consequences in this particular case, which we think fall into the category of exceptional.
Because, my lord, of the specific contradictions between 179 and 182, the reference in 179 to the fact that both conditions must cause much suffering and distress, both for the individual and the individual's family. And then in 182, there is no consideration of, other than the use of the word crisis in that paragraph, but there's no consideration of how this particular case differs from that anticipated in 179 of much suffering being caused to the individual and the individual's family. If the FTT had said, although ordinarily these sad conditions sadly are not uncommon and they do cause suffering to not only the individual but the individual's family, however, in this particular case, we find that the suffering was to a greater degree because of X, Y, and Z, then the FTT would have been entitled to do that, undoubtedly.
But is it a question of finding suffering? The focus, I haven't got the paragraph right in front of me, is on not only the sister but the minor children.
Yes.
And essentially the lack of care for them. That's not making a comment about suffering, for example, by the minor children. Can you not say it's a different page? The need to care for the twin sister and particularly for her minor children at a time of crisis.
But the only need to care was because the sister's alcoholism had caused suffering and distress for the children. Now give rise to the care.
Well, is that Is that what the findings were? I mean, it was more the children needed. I don't recall any specific findings about suffering by the children. But I do recall our attention was drawn to not only the house was in a mess, but essentially the children were too.
I'm sorry, my lady, we may have cross purposes.
Yes, I mean,
that was what I meant by the suffering, the
Physical.
dirtiness or the nits of the children I considered
Okay,
would
so
be
that's
there.
what you equate with suffering.
Yes, suffering or distress.
I think there is a finding that the children were distressed at their mother's condition. But that, as my lady says, is different from being upset because your mother is ill is different from being neglected. And they're different things, aren't they?
And
The Upper Tribunal understood the FTT to be for the meaning to be in the way that I've submitted, which gave rise to that inconsistency. If the court considers that the FTT meant something different by reference to need to care from alleviating suffering and distress, then I accept that there is not that inconsistency.
Right.
And then that takes me to ground 6, which is whether the tribunal was entitled to find there was an error of law by the FTT because there was no evidence to support its finding that the statutory conditions were met on each day. As I said earlier, this is again an Edwards and Bairstow challenge on the basis that it wasn't open to the FTT to make the findings it did because there was no evidence before it once it had disbelieved the taxpayer on the suicide on which it could make those findings. If I could invite you to go first, please, in the hearing bundle to 101. And if we pick it up at paragraph 185 in the FTT's decision, you can see in the second half of the paragraph, the immediate need to seek to establish a stable household in which the minor children could be cared for does seem to us to be an exceptional circumstance outside the appellant's control. So they find that there was an exceptional circumstance. We accept it would not have been in the UK, that the appellant would not have been in the UK at the end of each day, relevant to the appeal, but for the fact that she needed to care for both her twin sister and her minor children. We further accept that this need prevented the appellant from leaving the UK until such time as she had stabilised the situation and that she intended to leave the UK as soon as possible. So that is not a finding which is not specific to any particular day, but it rather covers the periods in issue. Then if we turn to 186, we accept that the appellant could not remember in any detail what she was doing on each day that she was present in the UK. Her evidence was that she had spent her time keeping her sister occupied and looking after the children. We accept her evidence and do not consider that an itemised timeline for each day, as was suggested by HMRC, was necessary. Instead, we accept Mr. Kessler's submission that if the reason for the appellant remaining in the UK was the same each day, and if that reason constituted exceptional circumstances, then that reason remained valid for each relevant day. And my lord, that was a submission that Mr. Kessler made to you towards the end of his submissions, which was that if the exceptional circumstance was found and that remained constant, then the other elements were satisfied as well. But they're quite different elements of the statutory test. You may have an exceptional circumstance which remains constant or consistent throughout the 4 or 5 days, but there was no consideration by the tribunal of, for example, why the circumstances prevented the appellant from leaving on one day, but did not prevent her from leaving the next day.
Well, the last sentence of 185 says that the need prevented her from leaving until such time as she had stabilised the situation. So if you read the two paragraphs together, aren't they saying that for all the days on which she remained, she had not yet stabilised the situation?
And that is the jumping off point for the Upper Tribunal's how the Upper Tribunal dealt with this point, my lord, that there was a lack of evidence for that factual finding. So if I can invite you please to go to page 49 in the hearing bundle. The Upper Tribunal said at paragraph 87 that the starting point was the burden of proof being on the taxpayer. So page 49, paragraph 87 of the Upper Tribunal's decision started with the burden of proof being on the taxpayer. So the taxpayer needed to bring sufficient evidence in order to satisfy the statutory test. That is obviously common ground. And then the relevant finding being challenged was that one I referred to at 185. It then deals with 186, so paragraphs 88, by reference to what is said to be filling the evidential lacuna with a submission, and that's the submission that I've just referred to. And then at 89, the Upper Tribunal accepts that the reason could be the same. And then it goes into the paragraph 91, goes into what evidence there was to support the tribunal's finding. So paragraph 91, Mr. Stone submitted there was no evidence before the FTT to support his conclusion that the taxpayer was prevented from leaving the UK on the 18th or 19th of December because, inverted commas, she needed to care for both her twin sister and her minor children. The Upper Tribunal agree, and the Upper Tribunal was referred to the evidence that was before the Tribunal, not only the findings of fact by the FTT, but also the witness statements that were before the FTT. And it says, in respect to this first visit, the only evidence before the FTT about the reason why the taxpayer considered she was unable to leave before the 20th was that, inverted commas, speech marks, it took her 3 days to reach a point where she was satisfied that her twin sister was no longer at risk of taking her own life, and that was the first opportunity that she could return to Dublin.
Is that a quotation from a witness statement?
That's, just bear with me.
Or is that an FTT finding?
If you just bear with me a moment, please, my lady, I'll try and answer that question.
Because presumably there was oral evidence here as well.
There was oral evidence as well. Yeah. So, if I'm grateful to my learner junior. If we go to paragraph 79, sorry, page 79 of the hearing bundle. And if I can invite the court to read to itself paragraphs 48 and 49 together, and you'll see the relevant quotation is taken from another paragraph 49. So the point taken by the Upper Tribunal, my lady, is that within both the evidence that it looks at and within the factual findings, the only explanation that one can point to why the taxpayer was prevented from leaving earlier was this explanation here that it took her 3 days to reach a point at which she was satisfied the twin sister was no longer at risk of taking her own life. But as the Upper Tribunal identified, that evidence was disbelieved by the FTT. And to repeat a point I said this morning, we know that the taxpayer left on the 20th, so clearly she was not prevented from leaving on the 20th of December, but there was no evidence at all before the FTT as to the circumstances on the 19th, which was held to support a conclusion that she was prevented from leaving on the 19th, other than this one sentence here. Now, my learned friend in his skeleton argument has sought to identify passages that he says were evidence before the FTT from which it could make that finding. In respect to this first visit, they are paragraphs 32 and 48 of the FTT decision. So if we can start, please, with hearing bundle page 77. And look at page 32. Sorry, paragraph 32. Page 77, paragraph 32. What it says is the twin sisters' mental and physical health gradually worsened as time passed, but the appellant said that towards the end of 2015, matters worsened dramatically and her plunge into drug and alcohol addiction accelerated at a sudden alarming rate. The appellant said that with hindsight, she realised that up until that point, the twin sister had been a functioning alcoholic and very adept at hiding this illness from her and others. When the appellant moved to Dublin, the twin sister appeared to be coping both emotionally and financially. So that is identified by my learned friend, but of course says nothing about the what the circumstances were during the particular visit. And the second paragraph is on page 79 of the hearing bundle. And that is paragraph 48, which I've already invited you to read. And identifying that the twin sister was in a terrible state when the taxpayer arrived cannot, in my submission, support a conclusion that the taxpayer was prevented from leaving on, say, the 19th of December in this case. And in respect of the second visit, the points are the point made is the same. It's page 50 of the hearing bundle. If I could go back to the Upper Tribunal's decision, please. And you can see at paragraph 94, the Upper Tribunal quotes from the taxpayer's evidence, or the evidence recorded by the FTT at paragraph 167. And again, it is said, once again, it took me a few days to reach a point in time where I was satisfied that the sister was no longer at risk of taking her own life. I returned to Dublin at the first opportunity. Now this day was longer. It was some 4 days were being sought to be excluded by way of the statutory exemption. So the taxpayer left on the 5th day. But there's no consideration at all about the circumstances as they appeared to the taxpayer on the 4th day. So it may be right to say that the exceptional circumstances continued, but there was simply no evidence to find that that part of the test dealing with prevent could be satisfied in respect of each day. And to remind you, it was common ground that that is the nature of the test.
Is your point more that the evidence was founded on the risk of suicide, and once that is eliminated, because the tribunal were not persuaded about it, there is no evidence as to when she could have left if she only had the children and the non-suicidal sister to care for?
Quite, my lord. Because the only evidence as to why it took so long were the two passages the Upper Tribunal quoted. It took me this long to stabilise her so that she was not at risk of committing suicide. Once that evidence had gone, as you've seen, there was the taxpayer was not able to assist the FTT with what she was doing on a day-to-day basis. She was not able to explain why it took her 5 days on the second occasion.
Sorry, when you say she was not able to explain, was this covered in all? I mean, we don't obviously have transcripts. Evidence is not just what's in the witness statements. Was this explored in evidence? Do we know whether that was explored in evidence? Is there any discussion?
My name, what the Upper Tribunal had was the witness statement. So putting the taxpayer's case, you know, at its highest, as it were, as to what she was doing. Clearly there was then exploration in cross-examination. I'll be corrected if I'm wrong, but I don't believe a transcript was before the Upper Tribunal. But you have the findings of the FTT in that regard, that the appellant said it was all a blur, is a word that she used to describe the week. She was not able to assist the FTT with understanding why she needed 5 days rather than 4 days or 3 days.
So the UT didn't have access to transcript.
Can I just turn and check that point, my lady? I will just, my learned junior will try and check that point as quickly as we can, my lady. But the point is the Edwards and Bairstow challenge was raised in the grounds of appeal. On the basis that there was no evidence to support those findings of fact. The appellant had an opportunity, or the taxpayer had an opportunity to put in a transcript if it was said that, well, it wasn't covered in the written evidence, but it was covered in your evidence, and here's some relevant
Well, the
evidence.
FTT wouldn't normally have a transcript unless one had been arranged.
Quite so. This was a remote hearing. It may have been available, and if they wanted to make that point, they could have put in a note of the, the solicitor's note of evidence, or requested the judge's note of
Okay,
evidence.
I mean, the reason I'm asking the question is that finding that there was no evidence is quite a, as is well known, it's quite a difficult finding to make. I mean, you've got to search the haystack, haven't you?
My lady, I whilst the Upper Tribunal didn't quote from the Anna Cook case my learned friend refers to, its approach was entirely in accordance with that approach, which was to identify the finding of fact, identify why it's relevant, well, it's obviously relevant because it's part of the statutory test, identify what evidence there was going to support that finding, and it did that in its judgment, and there was no, my learned friend does not say that, well, in the FTT hearing I put forward, I suggested there was other evidence, neither does he say, well, in fact there was evidence below, and I do recall, my lady, there were closing notes of the facts by both parties that were put into the FTT. So that has just come to mind. So whilst appreciating that it is a Edwards and Bairstow, this element of an Edwards and Bairstow test is a high threshold, my lady, that is a threshold that we do say the revenue overcame in the Upper Tribunal. It established that once you had got rid of the alleged suicide, because the taxpayer was disbelieved, there was literally no evidence to explain why she was prevented from leaving on the 4th day of the second visit, or the 3rd day. And you haven't, the submission you've had from my learned friend is, well, the reason stayed the same, and therefore the other elements of the test must be satisfied. And that, with all respect, is wrong.
Can I just see if I've understood your position? As I understand it, you say that there is a disconnect between her evidence, as summarised at paragraph 49, which is it took her 3 days to reach a point where she was satisfied, no longer a risk of suicide, and the finding at 185, where they say caring for the twin sister and her minor children is a need which prevented her from leaving until she'd stabilised the situation, because the need which they accepted was not the same as the need about which she had given evidence, which included the suicide. And therefore, although she probably could have given some evidence about how long it would have taken her to stabilise the situation if she didn't have the suicide element to worry about, the fact that she gave evidence about suicide and was disbelieved means that she has no evidence going to why she was prevented by the circumstances which the FTT actually found, which did not correspond with her evidence. Is that a fair summary of what you've been saying?
If I can try to
Or do you want to
replay
add?
one point
Yeah,
back
of
to
course.
my lord. The important bit being that the statutory test has to be satisfied on each day, and each element of the test has to be satisfied on each day. So in order to find that the 6th day that the appellant said fell within the exemption did fall within the exemption, she had to show that there was an exceptional circumstance, that it was beyond her control, etc., but also, and that it prevented her from leaving the UK. And so she needed to lead evidence to show why, on the 5th day she was prevented from leaving the UK. The only evidence she led was my sister was suicidal and I needed to be in the UK on that 5th day in order to stabilise the household. There was no other evidence as to what she was doing on the 5th day, or the 4th day, or the 3rd day specifically.
Is there
We had-
enough? Yeah.
Sorry, I was just going to say, we had some contemporaneous evidence in the form of receipts, but what they suggested was that the taxpayer was shopping and went to Manchester one day. None of that could be explained. But there was, beyond that contemporaneous record, which was unexplained by the appellant, there was no evidence as to what she was doing on specific days, or why the situation on the 5th day was such that she was prevented from leaving on that day. So even if you accept on the first day you turn up, the situation is terrible, the house is a mess and the children have nits. Even if you accept that that created a need for her to stay in the UK, and if you accept that that prevented her from leaving on the 1st day, you have to ask what prevented her from leaving on the 5th day or the 4th day.
It might another way of putting it be she obviously did leave on the sixth day in your example. So another way of putting it might be that in practice necessitates leaving some evidence as to what changed.
Exactly. Yes. And I believe that is a submission I made earlier, the question of what is different that has allowed her to leave. And that is a point that is picked up by the Upper Tribunal. If I could take you back, please, to page 50 of the hearing bundle. If I can just show you the end of the Upper Tribunal's analysis on this point, and then jump you forward. It's paragraph 95. The Tribunal says, looking at the second visit, there was no evidence as to what the taxpayer had done or when, so as to stabilise the position, why she was prevented from carrying on out the steps sooner or from outside, or as to what had changed so as to allow her to leave on the 19th of February. So precisely the point my lady identified. Then there's one point in paragraph 96 which is to do with professional cleaners. Said that although it was said that they needed professional cleaning, there was no evidence as to when this was done, how it was paid for, when it was organised, and whether it could have been organised from Dublin. Paragraph 97 is the conclusion. Given the lack of evidence, the FTT was unable to make findings of fact on a day-to-day basis that the circumstances prevented the taxpayer from leaving the UK. And then there was a further ground of appeal that the Upper Tribunal accepted was another ground of appeal. It's not one that my learned friend has challenged in this court. We say that in our skeleton argument, and he's not come back on this point. But it builds upon the points that I've just been making. That's why I didn't sort of start with it as a separate pleading point. But if I can invite you to go to page 54 of the hearing bundle, please. And could I invite you to read paragraph 119 to yourselves, please? And the point is, you can see it in 121. It is very much the same point, but the FTT had found that it was the combination of the need to care for the sister and the children that were outside the taxpayer's control and constituted the exceptional circumstances. But there was no evidence and no consideration by the FTT as to how that combination changed over the 5 days. So did the children still need care on day 5? If the children did not need care after day 3, then clearly the combination did not continue up to day 5. after day 3, you would just have been left with the consequences of the sister's alcoholism.
There was no consideration at all by the FTT of that issue. And if I can invite you to read paragraph 123, please. There is some conclusion by the Upper Tribunal on this issue. And my lord, the only other point I wish to pick up on this issue is that my learned friend.
Just before you do that, that means that a taxpayer who's got to rely or who wants to rely on a combination of circumstances has got a fairly tricky line to walk, because if you first of all, you might be disbelieved on some elements of your circumstances, in which case you're not going to be able to satisfy the test saying that you were prevented on each day by the remaining circumstances, or the tribunal might find that some of the circumstances were exceptional and some weren't. So the taxpayer who says it's the whole situation which prevented me from leaving, without distinguishing between different elements, is never going to satisfy the test.
Well, the idea of a combination of circumstances, it may be rare. This is the first case, but the simple point is that the taxpayer who wants to establish the statutory test has to explain to the tribunal and be believed as to why she or he didn't leave sooner. You know, why were they prevented from leaving at an earlier date? What changed to enable them to leave, to pick up my latest point?
Okay.
And then the tribunal will look at what the reason was and will consider, well, were there exceptional circumstances, and did they in fact prevent the person from leaving as the appellant says they did?
So not unduly onerous. The final point I was just going to draw your attention to, my lord, was in paragraph 8.5 of my learned friend's skeleton argument, there's a table, and he went through the table with you. It's at page 124 of the bundle. And it is said that this is evidence of the tribunal conducting a roving approach to the evidence.
But these evidential, these paragraphs of the Upper Tribunal decision are not relevant to this ground of appeal. The short point.
They don't take him any further. My learned friend was not able, in my submission, to show you any paragraphs in the record of evidence which would have enabled the FTT to find that the test was satisfied on each occasion.
My lord, I was intending to come back at the end to deal with prevent, but I believe I made my submissions by reference to Lord Justice Nugee's comments. Is there anything further I can assist the court with?
No, thank you very much. Mr. Gessler?
My lord, just 3 short points I would make in reply. Firstly, on the question as to whether or not there was evidence for the tribunal to make the findings of fact that they did. I set out in paragraph 8.3 of my skeleton 9 relevant paragraphs, which I suggested provided evidence. I don't propose to go through them now, but simply refer back to those in my reply on that point. The second point was my learned friend drew a distinction between those who come to the UK due to exceptional circumstances as opposed to those who happen to be here when the exceptional circumstances strike. And he said that was a different fact pattern. This point was in fact addressed by the First Tier Tribunal, paragraph 151. Let me find it, and I can give you the page number. Yes, page 95 of the report. So this is what the First Tier Tribunal said about this point about coming to the UK. Thirdly, HMRC argued that the exceptional circumstances exemption applied only to persons who were already in the UK and while they were in the UK were overtaken by exceptional circumstances which prevented them from leaving. The exemption did not, according to HMRC, apply to a taxpayer who came to the UK because of exceptional circumstances and was then prevented from leaving by the same circumstances. We consider there's no statutory justification for such a limitation of the test. HMRC's view is entirely unsupported by the statutory language, so I just refer to that passage was not discussed in the Upper Tribunal as our answer on that point. The third and last comment I would make in reply concerns the consultation paper which came out as part of the process of enacting the statutory residence test, which is set out on paragraph 54 of the Upper Tribunal's decision. On page 44 of the bundle, the core bundle. And the Upper Tribunal say, quote, further support is provided by the government's response to the consultation on the SRT, the statutory residence test, cited by the FTT, which said our emphasis that the purpose of the new provisions was, quote, to introduce a statutory definition of tax residence that is transparent, objective, and simple to use. My lords, that is one sentence to summarise a 60-page schedule of provisions. It cannot be right to cite it as a general guide to every provision, especially in the context of paragraph 22.4, which actually at one point uses the expression that the taxpayer must intend to leave the UK when the circumstances permit, which is necessarily a subjective test. So although it's certainly right that as a general rule, our new statutory residence test is more objective and clear-cut and easier to apply than the older one, that isn't a principle to apply rigidly without considering the context, or I would submit to apply at all. Those are my submissions, so unless there's any further point where I can assist the court, I'll sit down.
Well, thank you very much.
Thank you.
We will reserve our decision. It will be sent out in draft in the usual way for any typographical or minor factual errors to be corrected. You're aware, I'm sure, of the embargo which limits the use to which a draft can be put, but I remind you of it. We will hope and expect that in the light of whatever we decide, you will be able to agree an order for us to consider. If you find that you can't, we will have short written submissions and we'll decide it without any further hearing. Thank you both, thank you all very much for an interesting day.
Do you feel they're treated differently now you have your new elevated status?
Only in chambers.